Good morning, ladies and gentlemen. Thank you all for coming back. Not that I gave you a choice, but I appreciate it. I hope everyone had a nice weekend. We are going to proceed with the defense case at this time, and you may call your first witness.
Your Honor, we're going to begin by playing portions of Ms. Zwerner's deposition.
All right.
Before the shooting on January 6, 2023, did Dr. Parker ever explicitly tell you that she would promise or agree to protect you from John Doe?
No.
And this would include protecting you from a potential shooting or any other assaultive conduct by John Doe?
Did she tell me those words? Is
Yes,
that what you're asking?
before the shooting, did she ever explicitly promise or agree to protect you from an assault by John Doe?
No.
On January 6, 2023, was the only time you communicated with Dr. Parker directly before the shooting was when you went to her office at lunch to tell her about the behavior in the lunchroom?
Yes.
After that conversation, did you have any further communication with Dr. Parker?
No.
Do you have any direct knowledge, personal knowledge, of how Dr. Parker responded to any report regarding whether John Doe had a weapon?
Yes, what Mr. Rawls told me when Mr. Rawls came and spoke in my room.
I'm asking for personal knowledge that you yourself overheard from Dr. Parker.
Herself speaking?
Yes.
No.
At the time you spoke with Dr. Parker in her office on the morning of January 6th when you left the lunchroom, did you have any knowledge that John Doe might have a weapon of any kind?
No.
Did you have any reason to suspect he might have a weapon of any kind?
No.
But you received warnings after you spoke with Dr. Parker about John Doe potentially having a weapon?
Yes.
And then you received subsequent information throughout the day about John Doe, or you either observed or heard things that made you concerned that he might have a weapon?
A little bit, yes.
You never told Dr. Parker that you had reason to suspect that John Doe had a weapon, correct?
I only spoke to her at the lunchtime.
And you didn't convey the new information that you gained throughout the day to Dr. Parker?
I only spoke to her at lunchtime.
Correct. Did you ever isolate John Doe from the class on January 6, 2023?
No.
And you never sought out guidance, Ms. Palladini or Mr. Rawls, on January 6, 2023?
No.
All right, and for the record, ladies and gentlemen, that video and the transcript are Court Exhibit E.
Your Honor, I would next like to read the 4 requests for admissions.
All right. Ladies and gentlemen of the jury, before cases come to court and are actually presented before you, there's something called discovery that happens where the parties exchange information. Defense counsel is going to read to you from some of that information in the form of what was a request for admissions. This is going to be admitted, the parts that she will read as Court Exhibit D.
Defense request for admission 4 to Ms. Zwerner. Admit that on January 6, 2023, before the shooting occurred, you did not receive any communication from the defendant expressly promising or agreeing to protect you from any risk of harm by John Doe. Response admitted. Request for admission number 11. Admit that before the shooting on January 6, 2023, you did not communicate to defendant there was a reason to believe that John Doe might possess a firearm. Response admitted. Request for admission number 12. Admit that on January 6, 2023, the only time you communicated directly with the defendant before the shooting was when you went to defendant's office and told her about John Doe's behavior during lunch. Response, admitted. Number 18, admit that on January 6, 2023, before the shooting occurred, you did not receive any communication directly from the defendant acknowledging that she knew that John Doe might possess a firearm. Response, admitted.
All right, and the court will provide you as Court Exhibit D a redacted version of that with the 4 answers. So we'll need to redact that. Okay. All right, next piece of evidence or witness.
Witness, Dr. Leigh Hagan.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, once again?
I do.
Follow me.
You may proceed.
Can you please state your full name and spell your last name for the record?
Leigh D. Hagan, Ph.D., and the last name is Hagan.
And what is your professional address?
I'm in Chesterfield, which is near Richmond.
And what is your profession?
I practice clinical and forensic psychology.
When were you first licensed?
In 1982.
In what state?
That was in Georgia.
Are you licensed in Virginia as a clinical psychologist?
I am, and I have been since 1982.
Can you please tell the jury about the type of practice that you have?
I consult with attorneys and testify, as I will today.
In the areas of forensic psychology?
Yes, where mental health issues are concerned.
And Dr. Hagan, can you tell the jury what is forensic psychology?
It is that intersection of issues of human behavior and legal questions.
Dr. Hagan, will you please tell the jury a little bit about your educational background?
Yes, thank you. I have an undergraduate degree in psychology from University of Virginia, and then I earned a master's degree in counseling from UVA. Thereafter, I went to the University of Missouri in Columbia, Missouri, where I earned a doctorate in psychology.
Do you have any postdoctoral training?
After earning my doctorate degree, that's the PhD, I have hundreds of hours of continuing education, almost all in the field of forensic psychology.
Dr. Hagan, do you have any advanced certification?
I do. It is my privilege to be a diplomate of the American Academy of Forensic Psychologists. A diplomate is someone who's been granted a diploma, thus diplomate.
And describe for the jury what the board certification process entails.
When I went through the process in the 90s, there were 3 hurdles I had to clear. First, I had to show sufficient evidence that my practice was indeed forensic in nature and that I wasn't a psychologist who just occasionally showed up in court. I cleared that hurdle. And the second hurdle, I had to write up to reports or case analysis from different areas of law, and that was submitted to a committee to see if my work was up to snuff and met their standards. I cleared that on the first pass. And then finally, I flew across country for an oral examination by a panel of other psychologists who were already board certified. I cleared that on the first pass.
And you mentioned that you are a forensic diplomate. How many forensic diplomates are approximately in the Commonwealth of Virginia?
Well, of those who are in full-time private practice, last check there were only 11.
Are you a member of any major professional organizations?
I am.
Can you please tell the jury about those?
The American Academy of Forensic Psychology, the American Board of Professional Psychology, the Psychology and Law Society, and the Association of Family and Conciliation Courts.
Have you provided training for students?
Many times. For about 10 years, I presented each semester to the third-year law students at University of Richmond Law School. I was the director of psychology training for the doctoral internship program at McGuire VA Hospital in Richmond. It's been my privilege over the years to have individual tutorials, intensive independent study students from Virginia Union University, Virginia Commonwealth University, University of Richmond, University of Miami, Vanderbilt University, and William and Mary.
Do you provide continuing education for other professionals?
I certainly do. I've given many continuing education presentations to mental health professionals and others.
Do you provide consultation and supervision for other professionals in their forensic work?
Not supervision, but lots of consultation. In fact, just yesterday I was assisting another psychologist who had a thorny issue involving her court testimony. This Friday,
Hearsay. It can't. Anyway,
We'll move on.
Okay. Sustain.
Okay. Dr. Hagan, how many psychological assessments have you conducted?
at least 1,000.
And other than for private legal firms like mine, who else have you conducted evaluations for?
For the court-appointed attorneys, for prosecutors in a variety of states, for the Virginia Attorney General, and others.
And how many times have you qualified as an expert in court?
477.
And is that in state court as well as federal court?
State and federal court.
Is that only in Virginia, Dr. Hagan, or other states?
No, I have qualified as an expert in clinical and forensic psychology in Virginia, North Carolina, Maryland, Delaware, Pennsylvania, West Virginia, Ohio, and if I didn't say it already, Florida and Texas.
I would like to, at this time, move to qualify Dr. Hagan as an expert in forensic and clinical psychology.
Any objection or request for voir dire?
No, Your Honor. I note the objection.
Continuing objection, correct.
Yes, Your Honor.
All right, he is so qualified.
Dr. Hagan, who hired you?
You did.
And what were you hired to do?
To review records and develop opinions relevant to this situation.
And what specific issues were you asked to address when mental health professionals are in a forensic capacity offering opinions on a mental health diagnosis in court?
One, whether the standards for forensic mental health apply for a person conducting an assessment in a situation like this, and also to offer opinions on the methods and procedures that a mental health professional should use when conducting an evaluation and rendering a diagnosis, with full anticipation that that information will be used in court. And then finally, the third of 3 points, to offer information about the problems when offering a mental health diagnosis in court.
And have you ever met the plaintiff, Ms. Werner?
I have not.
What about Dr. Parker, our client?
No.
And I want to ask you to tell the jury about the information that you considered. Mr. Coleman, could you just publish that to Dr. Hagan only?
So there were 4 categories of information that I considered. The first was information from the plaintiff that she provided to the defense side that included her complaint and some other information. The second category I considered were the plaintiff's medical records, including her out-of-work notice from
Object, Your Honor. I don't know if the witness isn't offering any opinions pertinent to the plaintiff. 703 does not permit the witness to opine or to begin to testify as to all the information that they relied upon.
I'm sorry, he's just testifying to what he reviewed, and you're objecting to that?
Correct.
Okay,
In other words, he's just saying these are all the things I looked at.
that's overruled, it's relevant.
Okay. So the plaintiff's out-of-work note from February 14 of 24, and then there were some counseling records from a group called Abundant Life, both before and after January 6 of 23. And there was the Boulders Ambulatory Surgery Center, the North American Partners in Anesthesia, the Ortho Virginia records, the Riverside Orthopedic and Sports Medicine records, the Riverside Physical Therapy records, the Riverside Regional Medical Center X-ray records, the primary care physician records out of West Point Family Medicine, and the plaintiff's radiographs, as well as the Newport News Fire Department's patient care report from January 6 of 23. So that's the information provided by the plaintiff, followed by the medical records I reviewed. Then there were 2 other categories, the third being the depositions, the plaintiff's 2-part deposition, and I'm not sure if I can.
I think you can say what he reviewed, Your Honor.
Okay, as well as the plaintiff's mental health expert report and designation, Dr. Watson. And then there was the 4th category were other materials that I considered, and those included the following. Of course, Dr. Watson's report, and then Dr. Watson's deposition, the plaintiff's Empire Beauty School records, her grades, the requirements, her attendance, her performance, as well as the plaintiff's emails and her text messages before and after January 6 of 23, her Facebook posting, text messages between the plaintiff and her colleagues, and text with friends and other colleagues. And there's an agency in Virginia that licenses professionals to do certain things like hair, nails, and so forth. That's called the Virginia Department of Professional Occupation Regulations, to verify the plaintiff's license, and also to see what their requirements are for a person to become licensed as a hair person.
Dr. Hagan, is the information you considered of a type usually relied on for the purpose for which you were hired?
It is.
And are there any issues about which you will not be offering opinions?
Several. I'm giving no opinions whatsoever on liability. I'm giving no opinions about anyone that I haven't personally evaluated, and I'm not going to get out of my lane and reach into the job of the jury with any ultimate opinions.
As a result of the information you considered, did you form opinions?
I did.
And are the opinions you formed held to a reasonable degree of psychological certainty?
They are.
Dr. Hagan, when assessing whether the forensic practice standards apply, what standards apply to a mental health professional when offering a diagnostic opinion in court? Tell us about the forensic standards that apply both to a psychologist and a psychiatrist.
One of the sources of standards comes from the American Academy of Psychiatry and Law, and that standard says that a mental health professional's
Objection, hearsay.
You have a response?
He can state the basis for his opinion, Your Honor. That's clear in the case law. Otherwise, inadmissible hearsay forming the base of an expert opinion may be admissible for a purpose other than the truth, such as to demonstrate the basis of his opinion.
Are you personally familiar with the forensic standards?
I am, Your Honor.
Overruled.
So that standard from the American Academy of Psychiatry and Law says that a mental health professional's objectivity is enhanced when the professional considers all of the sources of information available when forming an opinion to be offered in court. That's one. Also, with which I am very well familiar, the American Psychological Association's Ethical Principles and Code of Conduct, 9.01, says that when offering an opinion, if the evaluator is aware of certain information that he or she didn't develop or wasn't available but could be relevant and helpful, then they have a responsibility to tell their audience in their report or through their testimony what information wasn't available and how the absence of that information could negatively impact the conclusions they ultimately drew.
Dr. Hagan, as a result of everything you reviewed, what opinion did you reach about whether the forensic assessment standards were applicable to a mental health professional's assessment?
I offer the following opinion to a reasonable degree of psychological certainty. Those standards which I just cited are applicable when a mental health professional offers opinions having assessed a person for the purpose of litigation, that is, for going to court.
And what is the responsibility of a mental health professional when offering an assessment of a person in court for litigation purposes?
To explore all of the sources of information that could be relevant and helpful, and to identify those sources that could have been useful but weren't available or weren't available at the time, and to state what impact the absence of that information could have on their ultimate opinion.
And does that relate to issues about the amount of the source of information that the mental health professional has?
It does.
Okay, and what about reliance on self-report versus other information?
Well, self-report means when the person who's being evaluated comes in and tells the evaluator things, information. A good starting point. But it's not the end point. It's important for an evaluator to consider all of the information, including information that may not line up exactly with what the person said. Just like in court, under direct exam, you're not just going to hear my answers to these questions. There'll be cross-exam, so the jury can figure out what weight to give what I have to say. That's analogous to when an assessment is done. You would ask the person, how are you doing? How are you feeling? What's going on? What seems to be the problem? But when it's done with reasonable foreknowledge, that is, you know in advance that this is going to be used to assist a judge or jury in determining a legal fact, then there is a responsibility to develop collateral informants and to review records so that you have the full movie of the person's life rather than a snapshot at a moment in time.
Does the mental health professional rely on any psychological testing?
Objection, Your Honor. It's outside the designation, and I don't know what we're talking about.
All right. What is, do you have a response?
I'm sure it's in his designation. Do you want me to? Your Honor, the report is 23 pages. I will not spend the time going through it now. I'll move on to something else. There's plenty of other things we can talk about.
That's sustained. Go ahead.
Okay. Does the mental health professional consider the person's adjustment prior to the index event for which they have been engaged?
Yes, the mental health professional doesn't cherry pick the
I
information.
object. The question isn't, does this person do this or that? This person's been proffered to testify as to what a mental professional ought to do or should do. And the framing of the question is, do they do this? Do they do that? Do they do this? Isn't appropriately frame the issue within the context of what he's been proffered to testify to.
All right, you have a response?
I can rephrase the question. Should a mental health professional consider records and information prior to the index event?
Yes.
And where would one gain that type of information?
Well, from what the person tells them and what they read from other sources. They need to have an appreciation of the context of why are they even getting this referral? What's the question to the evaluator?
Does the mental health, or would a mental health professional consider functioning prior based on collateral interviews and such?
Absolutely.
And Dr. Hagan, what is the mental health professional's responsibility if they don't do all of the things that you just said?
They have a responsibility to their audience to say, here's some things that I didn't develop. Here's some things that I sought, but they weren't available to me when I formed my opinion. And here's how the absence of that information could impact the opinion that I developed.
Do you hold all of your opinions to a reasonable degree of psychological certainty?
I do.
Go ahead. Thank you, Dr. Hagan.
My turn?
Yes. Object. This is a,
Is a roadmap?
yes, we're not doing a roadmap.
A roadmap every witness.
You can do a roadmap with your witnesses, but not with mine.
All right, I'm going to sustain the objection. Don't need to give him a roadmap.
Dr. Hagan, you ever heard of the phrase armchair expert?
Yes.
Okay. And you testified earlier that a job of a forensic psychologist is to, I think it was, assess the intersection of human behavior with legal questions. Is that right?
That's the definition of forensic psychology.
So that's a yes? That's
It's not a yes. I'm clarifying that that is the definition of forensic psychology. It doesn't dictate what a forensic mental health professional does in each case. It needs to be driven, the conduct in each case needs to be driven by the standards that apply and the facts specific to the case.
and that's your opinion because you, in fact, didn't address the intersection of human behavior and legal questions in this case because you didn't evaluate Ms. Zwerner. True?
False.
You evaluated Ms. Zwerner?
No.
That's all I need to know. You did not evaluate Ms. Zwerner, correct?
I have not.
And so when you said you performed 1,000 psychological assessments, all 1,000 of those are people who are not in this courtroom. True?
That's true.
And you said that you testified, hundreds and hundreds of times. You testify almost every week.
No.
You testify a lot.
477 times.
Did you testify last week?
Not last week.
Soon, recently.
In October.
Okay. And when you were asked what you would be opining on, you agreed that you wouldn't be offering an opinion on liability, correct?
True.
And in your experience in forensic psychology, that's a, quote, legal question, correct?
Well, it's outside of my area of expertise, the liability question is. So I'm going to stay in my lane.
All right, let's stay in the lane then. And that lane in other circumstances included actually providing an evaluation of somebody at issue, true?
I have done that, yes.
And you understand that the court can order that you provide an evaluation of somebody if it's requested?
The court can order it, yes.
And that defense counsel, if they wished, could ask you to perform an evaluation, true?
Objection, Your Honor. First, it's leading. It's not relevant. That's not an issue before the court.
All right, well, it's cross-examination. I'll allow him to lead, but what about relevance? You have a response to that?
Yes, Your Honor. The assessment is he's been offered to testify as to what a forensic psychology is helpful to do, and in this case, we're trying to figure out what he did, what he didn't do, so that the jury can understand how best to use or to evaluate his opinions.
Your Honor, Dr. Hagan has no input on defense counsel's decisions with respect to whether there would be an evaluation. He was very clear that he said he did not personally evaluate her and didn't need to offer his opinions.
Can you ask your question again, Mr.
Sure.
Neon?
Were you asked to evaluate Ms. Zwerner?
No.
Overrule the objection. Go ahead.
Did you ask to evaluate Ms. Zwerner?
No.
You understood that a question that this jury would be asked to decide is damages, correct?
Yes.
You understood that a question that this jury would be asked to decide is causation, correct?
Yes.
And you explicitly within your report stated, give me a moment here, that you will give no opinions about persons whom you have not evaluated, true?
True.
So you're not opining as to any, you did not offer any opinions as to her mental health diagnoses, true? You did not offer it in your report, true?
I'm not giving any opinions about her diagnosis. I have opinions about how the diagnosis was reached. the methods and procedures, giving no opinions about the plaintiff herself.
So to answer my question, the answer is yes, correct?
The answer is the one that I just gave.
Okay. And so, when we're addressing this specific issue in this case regarding post-traumatic stress disorder, you did not render any opinions regarding post-traumatic stress disorder, correct?
I rendered opinions about how that assessment was done. I'm not giving any opinions on the truth or the validity of the opinions.
That's because you didn't want to get your hands dirty and
It's
actually
because I'm
address it.
staying within my lane and not offering any opinions about anyone that I didn't evaluate myself.
Because that would violate its own ethical rule, true?
I think that is true.
There's the Goldwater rule that says you shouldn't be offering opinions about people who you haven't assessed personally, true?
I'm not familiar with it under the Goldwater, but I know under the American Psychological Association's Ethical Principles and Code of Conduct, published in 2016, section 9.01 through 9.03, it says you shouldn't do that, and I'm not doing it.
Thank you. No further questions.
Any redirect based on that cross?
Just a little follow-up. You were asked about whether you needed to evaluate Ms. Werner to offer your opinions today,
I was asked that.
and you addressed that when you spoke to the jury the first time and said you did not need to do that.
First time, and second time, and third time. Yes, ma'am.
Thank you, Dr. Hagan.
May he be excused?
Yes.
All right. You are excused from your subpoena. Please do not discuss this case. All right. Thank you. You may leave the courtroom.